The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Please be seated. This morning we are here for 3 cases to be submitted, 2 by oral argument. The case of Sandoval versus State of Iowa is hereby submitted without oral argument. We'll start this morning with Larew versus Hope Law Firm. It's my understanding Mr. Lerner will go first as appellant, but the rebuttal will be by Mr. Kelinson.
That's correct.
Okay, thank you. Mr. Lerner, you may begin.
Good morning. May it please the court. Counsel. I'm Dean Lerner, along with Craig Kelinson, who will offer rebuttal. We represent Attorney James Larew. Jim is here today, as is his co-counsel on the Swanee case. That's the subject of this litigation. Although the district court committed errors at law, the court found many facts that provide the underpinnings of Larew's claims. And the district court hit the nail on the head when it concluded, the fact is that this lawsuit probably would not even have been filed but for the efforts of Larew, which resulted in a jury verdict far exceeding anything the defendants ever imagined.
Could you move the microphone closer to your mouth? I got a message that they can't hear you on the system. Thank you.
Certainly. Given this district court conclusion, a counter-hypothetical scenario puts this case in context. What would have happened if Jim and Claire hadn't earned an award of over $1 million for their client and instead suffered a defense verdict or minimal recovery? That leads to a few sub-questions, and I'll try to make these brief. Would Mr. Hope have rushed up to Minnesota to inquire about the case he had abandoned over 5 months before? Would Mr. Hope have insisted on invoking the terminated of counsel agreement, offering to reimburse Jim's $40,000 in expenses and compensating him for the office and administrative assistance he failed to provide under that contract? Would Mr. Hope and Mr. Burke have met with Hope Law Firm attorney Gary Hill and discussed their plan to fire the attorney who tried it? Would Mr. Hope and Mr. Burke have contacted Sorrow and Bergstrom, the Minnesota attorneys, to join the case and hastily driven up to Minnesota with a $5,000 check for them to come aboard? In addition, would Mr. Hope and Mr. Burke have promised $40,000 in hourly fees to Sorrow and Bergstrom and a 5% retroactive contingency fee? If a post-trial meeting was to have been arranged with the client, would Jim have been informed and invited to attend, which we all know he was not? The answers to these questions, of course, are clear. None of us would even be here today if Mrs. Anderson had won nothing and Larew's risk of no recovery had materialized. There are many more questions that could be asked, but let me ask a final question, a more direct question. Why did Mr. Hope submit a sworn declaration to this court, to the district court, admitting it was his and Mr. Burke's idea to seek to remove Jim from the Swanee case, then repeatedly testifying at trial and submitting in briefing to this court at least 5 times in explicit detail that it was local counsel Wilson who had originated the plan to fire Jim?
What was the legal relationship between Larew Law Office and Hope Law Firm at the time of the Swanee trial?
Were co-counsel.
And they had both appeared in the Swanee litigation?
Yes. Pro hoc vici.
The of counsel agreement was terminated at that point, at the time of trial, correct?
And there had been a 5-month gap between any participation whatsoever by Mr. Hope in the case.
What role, if anything, does Rule 32.1.5 play in this case, which requires that when two law firms are going to be splitting a fee or sharing a fee, that the terms of that need to be disclosed to the client needs to approve of it, et cetera?
The fact of the matter is, Mr. Larew has admitted he made a mistake in not having discussed this with the client. And in the heat of battle, in the heat of trial, it was his determination that it would be wise and advisable in the best interest of the client to not approach her with this quandary, because he would have had to have discussed it with Mr. Hope as well. And Mr. Hope had already threatened, if Jim were to get a different separate contract with her, that he would sue both of them. And that's in the record before you.
Well, I understand that, but his duty is to his client, correct?
And he admitted his...
On the fee agreement issue?
He admitted his mistake, that he should have approached her, and his judgment at the time...
Reported on the fee issue.
I don't believe that either of the attorneys have self-reported on that issue. The reason for Hope's claim that the...
I mean, cases in Minnesota, is it covered by the Iowa Rules of Professional Conduct?
Well, you know, when you're practicing in Minnesota pro hoc vici, I would think you would be subject to their ethical requirements, Your Honor. And that makes perfect sense. But to my mind, a mistake, later admitted freely, is different than malfeasance. And the malfeasance occurred with Mr. Hope when he went up to change the relationship with Mr. Larew to Mrs. Anderson.
Over here. Counsel, there you go. So if we're going to talk about hypotheticals, didn't Mr. Hope offer to actually withdraw from this lawsuit prior to the trial, taking a 5% split, and your client would be able to take the other 95%? And wouldn't that agreement have actually settled all of these things, and we wouldn't be here?
Discussion, but it all fell through. They had reached a determination as to the vision of the cases, who would take which case, but they could not agree on the fees, and Mr. Hope believed that that was a package deal on all of the cases, and that it wouldn't apply on a single case. But I think it reflected, quite frankly, the relative value that he attributed of his contribution to the case, 5% at that time.
That also would have allowed your client to meet his ethical obligations as far as the relationship with his client.
Pros of battle, the May termination of the of-counsel agreement corresponded with this Mr. Hope's withdrawal from the case entirely. He had very little involvement even before then. But going forward, I've lost my train of thought there, but can you pose the question again?
Answered my question, thank you.
In a nutshell, why did the relationship deteriorate?
You can read through a whole lot of emails that essentially sum it up. Mr. Larew was displeased with the conduct of Mr. Hope and the conflicts that existed in many of the cases that were of great concern to him. And that's why in December of 2012, he said, take my name off the website as of counsel. And when the OCA was terminated, the of counsel agreement, at that point, it went from an of counsel agreement to a co-counsel agreement on the remaining cases.
Here's my, excuse me. I think my view, and I'm just one, is I think you have a lot to talk about on some of the other appellate issues. But on the issue of the overall, kind of pie, it does seem to me that the district court had kind of a fair approach. In other words, the pie has to be capped at what the clients agreed to pay, and what the clients agreed to pay was that $330,000, and the court said Mr. Larew gets 40% as long as the agreement was in effect, and 100% after that. What's wrong with that approach?
Approach is entirely wrong from a quantum merit perspective, because that left Mr. Hope, when he went up to what I'll call crudely steal the case, in complete control of what he ended up getting.
But at the end of the day, the clients went along with it, right? I mean,
misrepresented in terms of why they went along with it. They were told that they concluded that Mr. Larew was still going to be involved. That wasn't the case, as you can see in the documents. Mr. Larew was cut out completely by the of-counsel agreement itself. And on that very day that the addendum was signed, it has a clause in it that says the attorney's fees that are reflected here are proportionate to the work that, and so that makes it okay under the ethical rules. On that day, October 31st, Sarah and Bergstrom hadn't done a thing on that case and hoped very little.
Does your client believe that Sorrow and Bergstrom aren't entitled to any payment?
They got they got, I think, $160 some odd thousand, and then Mr. Hope offered to pay them hourly $40,000 separately. But on the day that that addendum was signed, that retroactive contingency fee gave them $56,000 or so, 5%, and they hadn't earned a penny. Now,
claim that they should be paid, the Sorrow and Bergstrom firm?
They're sort of out of the picture at this point. This dispute is between Mr. Hope and Mr. Larew, and
we have this pie, the 40%, and Sorrow and Bergstrom would take a piece, and Wilson would take a piece, right? And so really it's how we divvy up the rest of it. And what I'm trying to figure out is if your client is saying that that he should get, some of the Wilson and Sorrow piece also.
He's saying that his relationship is determined by what he was owed by Mr. Hope, and that amount is quantum merit, the reasonable value of his services.
Issue. So the modern cases indicate quantum merit's a theory of kind of restitution damages. Do you agree with that? Opposition.
Just repeat.
Is really a restitution theory of recovery.
It's an equitable principle that is laid out in the Watson case with a whole bunch of factors that the Watson court considered and a whole bunch of factors that you...
The justification under a quantum merit theory or a restitution theory that somebody would be in a better position than they would if the contract had been performed. In other words, it seems like the terms of the contract should set a cap on the amount of quantum merit recovery.
I think that'd be very unfair because Mr. Hope could have, in effect, come in, taken the case away from Mr. Larew, which he did, but offer essentially nothing that he would get, and therefore nothing that Mr. Larew would get. How fair is that?
Well, what I'm saying is he would be compensated for his work under a quantum merit theory, Mr. Larew, but the amount of compensation is capped by the absolute best case that he would have had under the contract. So why should he be better off under this theory of recovery?
It's an equitable concept and should take into account all of the various factors that
It's sort of a gap filler when there isn't a contract. So here the clients signed a new agreement and they added in this other Minnesota law firm that came in and gave them a share of the fee. And if Mr. Larew has a beef with the Hope law firm for, you know, conspiracy or fraud or something like that, that would be a count of a claim of that nature. But it wouldn't be quantum merit because quantum merit would be capped at the 330, wouldn't it?
time is up. May I answer? Can you just pose the question one more time for me?
I'm following up on Justice McDonald's question. You know, why isn't the 330 the cap in terms of a quantum merit recovery? Because quantum merit doesn't allow you to rewrite a contract. It just allows you to fill in a gap when there isn't a contract or a contract fails.
Determined by the district court, and we agree with that determination. And the implied in fact contract, which the district court kind of failed to discuss the metes and bounds of that contract, was that Mr. Larew would take that case and he would take the case to his conclusion. He had assumed all the risk for that. He had paid all the expenses for it. Mr. Hope sat back for 5 months, didn't do a thing, and when it became worth more than $1 million, he developed a scheme to go up and essentially steal the case. And if those facts aren't taken into account in this, in terms of a quantum merit evaluation, I'm scratching my head.
One follow-up to that. So the restatement on restitution, Section 38, which relates to the measure of damages under quantum merit, and has a lot of comments specifically referencing contingency fee agreements for lawyers, indicates that the value of quantum merit shall not exceed the value of performance as determined by reference to the parties' agreement. And that seems to be fairly black letter law all across the country, that's the cap. You can't do better than you could under the contract. So why should Mr. Larew be able to exceed that in this case?
Completely. Mr. Hope's conduct in breaching the implied in fact contract and essentially robbing Mr. Larew of the fruits of his labor thus far, and it even robbed him of the ability to finish off the bad faith proceeding and perhaps recover more for the client. This was not at all in any way in the best interest of Mrs. Anderson to, in the middle of that trial, steal it away from the lawyer who had won the verdict. And if that stuff isn't taken into account, we're in trouble. Thank you very much.
Mr. Stoltze.
May it please the court. Bruce Stoltze on behalf of Hope Law Firm and the other defendants. This case is essentially a dispute between two law firms about fees. And the question is how much fee should be paid and split?
Should pay it? I have to say, I am baffled why the district court didn't find successor liability in this case. It seems to me, you know, Hope Law Firm under one name closed its doors and opened its doors under the same ownership and another day the next day. So help me out. Why isn't there successor liability?
Successor liability would apply when one corporation goes out of existence and the other one continues, or the other one starts. In this case, Hope Law Firm P.L.C. continued. P.C. is both law firms are existence.
Counsel, hasn't it? I mean, isn't it just an empty shell now? I mean, it's not handling cases. It doesn't have employees. It has hardly anything in its bank account. I mean, as I understand it, it kept, the new firm took all the cases, kept the same name, same phone number, same website. It looks pretty similar.
It has gone down to where it is not actively involved in the practice of law at this point. When the separation occurred, it occurred when the tax laws of this country changed.
Tax benefit of this conversion. I want to know that.
You know, if I was an accountant, Your Honor, I'd be able to tell you. I don't know but.
And I don't understand it. You went from a pass-through to a Schedule C. It doesn't make any sense to me that there would be tax benefit. The tax laws changed just 2 weeks before this 2 to 3 weeks before this change was made. That would be remarkable, speedy analysis and work by an accountant to figure out that there would be some tax benefit. What's the tax benefit? Is there any evidence there was any real tax benefit?
I don't believe that the tax benefit is in this record because it never became an issue at trial, Your Honor. It never did. My understanding, but the problem is my understanding can be deficient here because I'm not an accountant, but I understand that the federal government passed a tax law that said that there are certain times when you can deduct monies and you can't, and there's run-through of those monies. I don't know exactly how that works because my accountant said I can't do anything about it for me. So I didn't get involved in it, and I don't practice tax law. It didn't come up in this case. I do know that Mr. Hope got tax advice, and he created the second corporation, which in fact did take over and do business. But that doesn't mean that there's successor liability. All of the transactions in this case occurred with Hope Law Firm. Everything did with Hope Law Firm itself. It had the fee contract, it dealt with everything as far as the money. All the monies came in, the trust account was kept with the trust account money that was at dispute in this case.
Law firm took over, like on day one, did all of the old cases that Hope was actually handling move from the old firm to the new firm?
Something about that. I don't believe that's in the record, Your Honor. So when law firms do these things, there can become obligations to pay the previous law firm for money from this law firm. There is no evidence in this case as to how much the second corporation owed to the first corporation.
It's about whether or not the second corporation paid anything to purchase the first law firm?
Evidence put into the record relating to any of that, no.
Was that then? So, I mean, we need to deal with the record that we have.
And the plaintiff could have put that information in.
I mean, you meaning your party below.
We could have put that information in, Your Honor. From the position of Hope Law Firm, we had accountant advice with whatever tax consequences flows out of that, and that was admitted, and everyone knows, and that's what the district court found, was that it was through this accountant advice. There was no nefarious thing here.
Purpose of this change in court from one entity to another to shield assets from Mr. Larew's claim. Could you address Iowa Rule of Professional Responsibility 32.1.15e that says when in the course of a representation, a lawyer is in possession of property in which two or more persons, one of whom may be the lawyer, claim interest, the property shall be kept separate by the lawyer until the dispute is resolved. Why wasn't this money, segregated in a trust account pending the resolution of Mr. Larew's claim?
Hope Law Firm approached this was, Hope Law Firm believed the 60-40 split would be applied and that the money is paid out of their business account and that there was a dispute as to how much money there would be paid. The issue becomes, in this case, looking back on it, we can say maybe they could have done it differently. But in point of fact, it's nothing different than when an associate gets a percentage bonus calculation and there's a dispute about how that bonus calculation is made. The money goes into the law firm's business account and it isn't kept separate from anything else until the associate gets paid. When money comes in, when partners agree that they're going to divide percentages, the money doesn't stay in the account until those disputes get
there. And I take your point, but the difference there is that's somebody that works within that law firm. Whereas in this case, you have, in effect, an outside party that Hope Law Firm never disputed that he was owed at least $130,000. And the record indicates, doesn't it, that instead of ever segregating that $130,000, instead of keeping it in a trust account, or better, even better, paying it to Mr. Larew, it went out the door. It was in the operating account and went out the door. That seems troubling, doesn't it?
Your Honor, it was in fact segregated, and there is testimony in the record indicating that the money went into the account and it was held in the account. I would agree that later on,
in the record, because that wasn't my impression of the record.
I don't have that in front of me right now, but I certainly will submit it as supplemental authority, Your Honor.
It was never protected though, right? It was actually paid out. When they went to collect on it, there was hardly anything there.
I would agree, Your Honor. I would, if I may, Your Honor, state this. The question becomes at what stage this court is going to say that attorneys must set aside fees that are earned under their attorney fee contract. The primary issue that I've tried to indicate from the beginning of this case is Mr. Larew chose not.
That question indefinitely until the dispute's resolved. I mean, Hope knows at minimum they owe Larew something for his representation and work in the case. Whatever that amount is in dispute. But why can't they at least set aside that minimum until it's resolved? And they didn't here.
That, I think that in fact can be a ruling that this court can make, that attorneys need to start whenever they're co-counsel on a case. Money has to come in, money has to be put into the account, and they are required to segregate that into a separate account and held separately until such time as all agreements with co-counsel have been resolved.
To piggyback off of a question of Justice McDonald's earlier to opposing counsel, he asked about whether his client had self-reported, and it makes me think about your client, Mr. Hope. In your own brief, you say HLF remain liable on and for the contract and for the legal and ethical processing of the case. You can't have it both ways, can you? You're saying that we were in charge, we were driving this ship or boat or train or whatever, and then on the other hand saying, point the finger at him. Didn't your client have responsibility as well as alleged here, ethical and legal?
I do believe that Hope Law Firm had the responsibility legally and ethically, as all attorneys do in the processing of the case. The concept of what should be done relating to that money and separating in separate accounts, responding to how we're going to do that. And I don't know that there's any cases that talk about this issue to give guidance to attorneys, and maybe that can be done in this case. But if there are
opinions where we've suspended Iowa lawyers for 30 days because they didn't segregate money where there was a dispute. And in our cases, those cases are clear. You have to hold it back until the dispute is resolved.
Attorneys, or between the clients and attorneys, or with subrogation carriers. In this particular case, there was one attorney fee agreement, and that fee agreement was with Hope Law Firm. That is, they decided, the Minnesota court said Mr. Larew had no separate contract with the client. It was therefore there. So the money is Hope Law Firm's money.
Email from the client, and the client authorizes payment of the fee to Hope Law and Larew Law, both. So at least from the client's perspective, both of the attorneys should have been paid.
There's no doubt that she said that. And in fact, Your Honor, if you look at Catherine Anderson's affidavit that she submitted in the Minnesota court, she in fact specifically said that she agrees that money should go to all of these law firms. She agrees that that should be resolved between it. The Minnesota law firm said they should come down here, that there was a dispute, the Minnesota court.
Quantum root equitable we've been talking about equity between the lawyers. Do you think that also includes equity as far as the client is concerned, so that the piece of the pie doesn't ever get to where she or he is not treated equitably?
It is important for the attorneys to make sure the client does not get caught in the middle, Your Honor. Yes, it is. Yes, it is. And that is the position that we've taken on division of this money. And these other issues, I think, are issues that the court, I can understand the court wanting to give some guidance to lawyers relating to this relating to these specific issues. But Mr. Larew was told, get a fee agreement or you're bound by the 40-60% distribution. He intentionally chose not to do it and operated without any fee agreement thereafter.
The client specifically stating that Larew would not be paid pursuant to this. What communication did you have to tell them he's out of the picture?
That occurred at the time that the new counsel came into effect in November. That did not occur back in May because the attorneys, Your Honor, were trying to work this out as to how that was going to be divided.
Well,
It did not work out. And that is,
I mean, there's kind of one other piece to this, right? I think starting in March or April, your client, I don't think, did anything on this until after trial. And so how do we, work that in, that your client would get 60% of this when in the 5 months leading up to trial they didn't do any work? I don't think. Am I wrong about that?
that would be true, Your Honor. That would be true, Your Honor, that there was not, that Mr. Larew was handling that. It's no different than when my associates handle the cases. I don't meet the client. I don't work with the client. I don't do that. The associates or my partners handle the cases. The money comes in.
Associate or partner still getting along.
Yes. Well, that is a difference. That is a difference. But Mr. Larew could have gone to the client and didn't go to the client to get the agreement. Mr. Larew operated under the Hope Law Firm agreement. So the question, Your Honor, becomes this. What the district court did was say, all right, we're going to allocate time before and after the termination of the OCA. We're going to go by the 60-40 split up until the OCA is terminated, and then gives 100% of the money to Mr. Larew thereafter, despite the fact that Mr. Larew did not enter into an attorney fee contract, did not talk to the client about it, did not do anything about it, and did not carry out that issue. He did try and win the case, but if
Fall of not having an agreement, got a great end result.
Send Larew an email and said, don't approach the client about this, because if you do, I will sue you for tortious interference with the contract, and you need to tell the client that the client's still on the hook for the Hope fee. So you're acting like Larew just passively didn't want to do it when he's told that he's going to be sued if he does.
The responsibility of an attorney is to go to the client and tell them that and get a fee agreement. That should not be something this court should equivocate on. The responsibility of the attorneys of Iowa should, in fact, be to get that fee agreement when they leave an agreement with another attorney. To do anything different, to give Mr. Larew 100% of the money, even though he operated under the...
What was your client's responsibility to his client to tell the client that Mr. Larew is no longer associated with his firm then?
I don't believe that there was a belief, may be mistaken, Your Honor, that they needed to tell the client because it was thought he was operating under their fee agreement.
I think that it's okay to have a mistaken belief about what their responsibilities are, but not necessarily the other side.
Well, there's certainly, the clients certainly found themselves, and the parties to this case found themselves in that situation, Your Honor. Looking at it from the outside, it seems as if the decision was made to be under the Hope Law Firm contract and not to enter into a new contract. And when that changed after the trial, Exhibit P that went into the record shows that if the division had been done at that time, Mr. Larew would have gotten the amount of money that we're saying he should get. He performs, He performed services up until that time, and he would have gotten that percentage. Therefore, that is a fair percentage if that had gone on. The question becomes, I understand your honors are involved with, are concerned about the issues of attorneys responsible to the clients. And our briefs indicate that the court should address those issues. But when it comes down to the division of the money, giving Mr. Larew 100% of all money that accrued from the time the OCA terminated until the jury trial, despite the fact that he kept an attorney fee contract in effect under the Hope Law Firm, is not fair or equitable, or it shouldn't be the law. There should be an instruction saying to the lawyers, you're going to leave a law firm and you're going to have a contract and you take the client, get out to that client, get that agreement in effect, or you're stuck with whatever fee agreement existed prior to that time. You can't argue about that.
Didn't you guys say game over? Aren't you the ones? Isn't it your client who said you're no longer going to have this contract? I mean, he didn't walk away. You guys pushed him out the door.
Actually, it's not quite that clear, Your Honor. If I may, I'm sorry, I know I'm out of my time, but it's not quite that clear, Your Honor. Previously, the parties got into dispute about these issues, about how cases were being handled, and the case and the situation deteriorated. Therefore, in December, there was an agreement that Mr. Larew would no longer be on the letterhead and wouldn't be on the door anymore. That was agreed. Then the parties tried to reach an agreement as to what was going to happen. Now, Mr.
True, though, that a meeting was held without Mr. Larew present, where arrangements were made with Hope Law Firm and the client, and he was not a part of that.
Yes. And then he submitted a letter to the client explaining all of it.
One final question, because you are way over your time, but you say in your brief that there has been a bond filed. How much is the appeal bond?
The bond is whatever is required for the bond. It's 125% of the judgment, or whatever the amount was. There was a bond, and I don't know whether they add interest on it or anything. There was some calculation made, but there is a cash bond pending that is existing.
Briefly about the conversion claim and punitive damages. So generally, we wouldn't recognize a conversion claim relating to money, and there are exceptions for money that's a chattel or money that is in a segregated fund or should have been in a segregated fund. If we conclude that the money that's in dispute should have been placed in a segregated fund until the dispute was resolved, why wouldn't there be an action for conversion here? And why wouldn't there be an action for punitive damages? Because clearly the money was converted, right? They executed on the prior law firm, the money's gone. Why shouldn't he be allowed to recover now in tort for that damage?
There was that money, Your Honor, at the time, that money was owned by and had been determined by the Minnesota court to be owned by the Hope Law Firm. There was not an understanding that there was a dispute that involved that specific money, but rather a contractual claim. And if the difficulty becomes whether or not that rule then converts into a conversion action when in fact it was legally decided before then that Mr. Larew had no possessory interest in that money. So the question becomes whether or not that kind of situation should be required by the court and there would be a conversion.
Regarding the attorney fee lien, is that what ruling in Minnesota?
Two rulings by the district court in Minneapolis that said Mr. Larew had no possessory interest in those funds. And the district court told the parties at that stage, Your Honor, the situation here is for Mr. Larew to go down to Iowa and bring a lawsuit and try to prove his right to how much money would be paid. And I think, Your Honor, the issue then becomes how lawyers are going to handle these disputes as far as when and how they have to separate funds out when there's disputes. Otherwise, we've said everything in the brief. Thank you, Your Honor. Thank you.
Excuse me. May it please the court, Craig Kelinson in rebuttal on behalf of Attorney Larew.
I'd like to start on that conversion issue. Of the OCA agreement, section 4.3 fees, it does seem as though these fees were permitted to be put into a general fund at the Hope Law Firm and commingled perhaps with other funds, and there wasn't any right to have them separately designated, at least under this contract. Do you disagree with that, or am I misunderstanding something?
I think the point here is, of course, that contract was gone by the time those fees came around. Whatever in defendant's argument about, well, you know, we put all the fees that collected by the fund, you know, by our firm in an account and we pay it out, and there might be disagreements, but it's all there. That had all ceased. Mr. Larew is no longer associated with the firm.
What replaced it? With respect to Justice McDermott's question.
Then we're on to the implied in fact contract. There wasn't
Agreement about what would happen to the specific funds when the client's relationship remained with Hope Law Firm.
Relationship remained with the law firm, but there was no formalized relationship. There was no definition of terms as between Larew and Hope and the law firm at that point. That's why the law implies terms to make that work. One of the terms that we believe was part of that implied contract, if you will, was that Larew was going to continue to be primary counsel and handle that suit.
Specific question of, because the client remained a client of Hope Law Firm, when the funds came into Hope Law Firm, what would have changed the original agreement that those monies would go into the Hope Law Firm operating agreement?
There was known at that point that Larew was no longer associated with the firm, but yet had an interest in co-ate vested, however you...
And maybe articulate sort of, and tell me if maybe I'm on the right track. So I think Justice McDonald is correct that generally speaking, you don't convert money. You know, you bring a contract claim if somebody owes you money, you don't have a conversion claim. If there is sort of a segregated pool of money such that it becomes kind of distinctive property, then that's capable of conversion. And I suppose if one could argue that under the ethical rules there was an obligation in the absence of any contract or anything else to hold this, the amount of money that came in that was indisputably owed to Larew separate and segregated, and not to put it in the operating account and not to spend it, then if that money disappeared, that would be conversion, and the individuals who engaged in it could be liable, and there could be potentially punitive damages. Is that kind of where we are? Possibly. At least under your view of the case. I'm not saying I share that view. I'm just exploring.
Recognition by Hope and the Hope Law Firm that those monies are owed.
The ethical rules, they don't, you can't sue on the ethical rules, but they can provide standards that define conduct. And if the ethical rules require you to hold funds separate and you don't, then that could have legal consequences in a civil context, isn't that right?
Of this case, in the broader sense, when we talk about the caps, whether the recovery caps things in this case, this...
Address opposing counsel's argument that the Minnesota court definitively resolved kind of the possessory interest with respect to the funds.
I do not believe that they did that at all. If to the extent that there's language in there to that effect, it's dicta. The essence of that ruling, the two rulings even, if you will, was that Mr. Larew did not have a contractual arrangement. He had an attorney-client arrangement with the client, obviously representing her, but he did not have a contractual arrangement with her, and that did not satisfy the statute, the Minnesota attorney lien statute.
That was relating to LaRue's contractual relationship vis-a-vis the client, not the both.
Correct. The point with applying the contingency fee arrangement as a cap or a limit on this, and I'm sorry my time has expired, but just a quick comment there is, there was no dispute in this case as to the value of the service that Larew provided. Hours times the rate, that was all agreed. His failure, if you will, is he put in too much work on the case. He exceeded, even though he got a great response, it exceeded that value that he was going to get out of the case. Thank you.
Case of Larew versus Hope Law Firm is hereby submitted. And we'll take just a few minutes here to transition to the next case.